The invocation will now be given by Mr. Mike Campbell, and our pledge will be led by Mr. Dan Gray.
Let's pray. Dear Heavenly Father, be with us today as we make these decisions and guide us, and we thank you for these and all other blessings. In Jesus' name, amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Chairman, would it be okay if I moved up one?
Yes, come right up. Not a problem, not a
I got to
problem.
put my hearing aids in this morning.
All right, we're here to deal with the amended bylaws based on the recommendation from the INR Committee and the public hearing. We need to approve the agenda. Is there a motion?
So, I make the motion.
Second.
Probably moved in second that we accept the agenda for this meeting. All in favor, make it known by saying aye.
Aye.
Opposes? Ayes have it, so ordered. Here's the final copy of the bylaws that we just received from the R&R Committee, and if you note at the bottom, it has bylaw amendments with R&R revisions dated September 29th, 2014. It's not redlined, but Attorney Britton is going to lead us in the changes based on the redline version you received on yesterday. So if you have your copy of the redline, then you can use that to follow Attorney Britton. And we're going to focus mainly on the changes that have been made.
All right.
Attorney Britton.
We will have one more version. There were a few last-minute editorial revisions, like inclusions of the or non-substantive changes that Mike will bring out. In conducting this review, there's some changes where we just corrected or changed grammatically some of the sentences. I'm really going to focus on the substantive revisions, and if you have any questions about anything else, we can certainly go to those. If we would turn to Article 7, which is on page 4. An issue discussed with the INR Committee yesterday was that the bylaws provide for the Board of Directors to include 2 ex officio members. The enabling legislation that the County Council passed did not include 2 ex officio members in that legislation. Council did approve the 1992 bylaws with a resolution and did not object to the 2 ex officio members, but there's an issue as to whether they legally constitute part of the board. They don't sit with the board, they've never participated in decisions, so it really is not an issue. It doesn't create any legal issues as to anything the authority has ever enacted or done. Because of that's been part of the board's corporate culture for 22 years and never been questioned, we asked the INR Committee for guidance because we didn't feel like the board could unilaterally delete it. It may hurt the feelings of the administrator and the League of Cities if we were to unilaterally do that. And so what the consensus reached at the INR Committee meeting was to delete the status as ex officio, but to specifically invite them to attend board meetings. So if you look at the bottom of page 4, well, first of all, the ex officio member sentences are deleted from Article 7, Section 1B. And then if you look down at the bottom of page 4, the 4th paragraph of subpart C, the board shall specifically invite the Horry County administrator or administrator's designee, and lately that has been Steve Gosnell, and a city manager or assistant manager who shall be identified by the League of Cities to attend all meetings of the board and shall provide them with agenda materials in the same manner as provided to the members of the board. So that is the language that we drafted afterwards, following the INR committee, pursuant to their guidance in that regard. Are there any questions about that provision?
We just have to send a written notice or call.
What, it would be easy, what you could do when you do, at the beginning of the year, publish the the
Right.
roster of meetings, you would send that to them, just like you
Sure.
send it to the press, and then you would send them the agenda materials for each meeting, just like you do now.
Right.
So really, it's not a
Not a
change in
it's a-
protocol.
no,
It's just bringing the bylaws into, strict compliance with the
Right. And
enabling.
Gosnell is the county, and we've got somebody from the League of Cities. It was Kevin Blayton, I think.
And generally the city manager follows the chairman of the League of Cities.
Okay.
And I think that's Conway, so, Graham will probably be coming back, or his designee.
Right.
What about the liaison for Highway 90?
That was never part of the guidelines or bylaws, anything like that. That was just something that, county council chairman had, appointed someone,
Right, to do that,
and that's not any in the rules,
That is
regulations,
more of an
anything.
informal designation.
Yeah.
right.
He'll
Which
continue
is-
So
to be
he'll
invited.
But he-
continue
yeah.
to be here.
Right.
Okay.
I mean, he's,
Nothing will change on how we doing business, it's just changing in the verbiage in this.
and that's Michael
Hughes.
Hughes. Right.
Now, I'll note, we did change code sections to the nonprofit code when the bylaws were passed in 1992. The nonprofit code had not been written and was, nonprofits were governed by the regular corporate code. So we did switch it over to the correct citations.
What page and paragraph?
Well, the code provisions are throughout the document. One example is Article 7, Section 1C on page 4. Instead of 33.8107, it's 33.31.807.
Dan, if you look at the document we gave you yesterday, it's in red. You can spot it a lot easier.
Right.
Yeah.
It's in red. That's it right there. It's just included in the other one.
What is that rhetoric or legal term that here and everywhere else disappears? There's a term for that.
Well, we did use the term at seek, and at seek means we're not going to cite every single SEQ. We're not going to cite every single provision of the code. It's nonprofit code, beginning with page 1, et cetera. But
I don't mean to take your time.
Yeah.
I understand what you're saying.
okay. All right, then if we go to page 5, we have a new provision there on the removal, which we discussed at length when we were going through our workshop or discussion of the bylaws. This removal provision is taken from the county's set of, or the county's provision in its code of ordinances for removal of directors on county-created boards, commissions, committees. The authority is specifically listed in that code, and so what we have done is mirrored the language as it applies to a board of directors in setting up in rewriting the removal provision. So this is the same, and we did add to it, if you will look at sentence 6 from the top of on page 5. We did put if a nominee by the league is being removed, not only will notice go to the board member concerned, but a courtesy notice will go to the League of Cities if it is a board member appointed by the league, from the league's nominees. And that way, the league is advised as to what is going on, so they will not be surprised by it and will have their input if they want to get involved.
Excuse me. So we're going not only on the I mean, we're looking at not only the changes that were faxed in this morning, but also the ones from yesterday.
From yesterday, yes, sir.
So if one is familiar with the ones that we got yesterday at the public hearing, there's no change.
You're talking about the courtesy copy to the league?
Yeah.
That was on recommendation of the county attorney.
Right, it was
In the
handed out
meeting
yesterday at the
afterwards.
public. That's when we got,
That's right. That's when we got that in the public meeting.
I read it last night, read it this morning. I certainly concur with that, but that's not new today. That was published yesterday.
Yes, sir. That was published yesterday in the red line version you got yesterday.
But
This blue is what is,
It's in blue. That's right. It was in yesterday's,
But we gonna vote on it today.
but we're going to vote on it today for this board. That was a change from INR yesterday, yes, sir. That's why the document is dated,
Yeah.
includes changes through yesterday.
Yeah, the efficacy of us voting is a separate subject, but we're not discussing that right now.
That's
We gotta, I'm just trying to make sure I understand where the white line is between what we got yesterday and what we had, what was faxed in this morning. And,
All right, we've got what was put in this morning, and why don't we kind of just deal with that separately after we go through the substantive changes? Because these are mostly non-substantive, as I understand. Not, they're more editorial,
yeah.
okay, stylistic,
As
Okay.
for, if I may,
which is common when you have different people working on a document. You have
Yeah,
different writing
I understand.
styles, so.
if I may, I'm thoroughly familiar with what was handed out yesterday, which included or dealt with the discussions between you and Mr. Knight and Mr. Karate.
Yes, sir, as
I'm
directed
thoroughly
by,
familiar with that. The only thing that would be unfamiliar with me today, and I guess everybody else here, would be what was faxed in. Apparently, the county made
Yes.
some more changes.
all right, we'll discuss those in just a minute, because I'm running through as quickly as possible what,
Yeah.
but not everybody on the board was there yesterday.
What,
So we're just doing an overview of the changes, similar to the presentation yesterday. So this board, the board members who weren't there, I know you and Ms. Creech and Mr. Campbell were, but then we'll pass out the other changes.
Okay, thank you.
All right, and we I don't think there's any, we've talked about the ethics, that's, nothing on that is a change, nothing in that change has been changed, okay. Page 6, again, we took that out because we felt like it was inconsistent with FOIA. That's when the board was acting in a more private corporate manner. Let's go to page 7, there is a change, small change here, based on INR. We actually added some language. If you will look at the end of section 8, we have taken the language that applies to county council in the South Carolina Code, section 4-9-660, which is authority of county council and its members over county officers and employees. It's not verbatim, but it's close to verbatim. The county also has elected officials, which they have a different status. So we did not need the language on elected officials. But we took the language pertaining to employees and added it, and that language is at the end. And it says, no, and that should be a capital N there, no board member shall be permitted, wait a minute. My section
your
was-
red line version?
Right,
it's section 9 on that red line.
let's see.
On
No,
page
You don't have-
It's
8.
not on my, that's right.
Right.
Oh, no, it's at the end of section 8. Look at, beginning with except for the purposes of inquiries and investigations, the very last sentence of the first paragraph of section 8, we added, except for the purposes of inquiries and investigations. Board members shall deal with SWA employees solely through the executive director, and neither the board nor its members shall give orders or instructions to any such employees. Now, this comes out of the code provision related to the relationship between the county and its employees. These inquiries and investigations would be like an inquiry or investigation of an official manner. In other words, if council is holding a hearing where they want records brought before them, then the individual council members can participate in that inquiry of council or investigation of council to participate in the questioning about the books and records. So in that limited process of conducting a SWA inquiry or investigation, if you bring people in to question them about that, the board members may participate in that. Otherwise, the communication is solely through the executive director, and since the code said solely through the executive director, we changed this provision to have the inquiries go through the executive director to be consistent with the code section that applies to the county council. Okay. We also, sure we have
Page
this.
9.
The pages on the officers, they had the duties of the officers, they had no changes on those at INR. I think we covered how those were rewritten, I think to be a little simpler and to more accurately define the current duties of the board officers. We've talked about those a good bit. The amendments and conflicts on page 10, we did provide, as we've discussed in this board, I believe at the last board meeting, we put in a provision on section 3, page 11, in the event any of the provisions of the bylaws conflict with any provisions of prior bylaws or the amended bylaws will control. In section 4, if there's any conflict with provisions of any ordinance of Horry County, then the conflicting provision is deemed repealed and no longer in effect. We discussed the dissolution at length with INR, and they proposed no changes to that. So that was accepted. All right, now we can go to the version that reflects the red line changes from INR, and we should be able to go through those quickly.
You need another copy of him, Mike. Yeah, from INR.
And this is what
This
was
is-
proposed after the meeting yesterday.
Yes, after the meeting yesterday, Arrigo, Danny, Mike, and I met,
Right.
and we sat down and hand-wrote changes to the document.
Right.
And then Arrigo sent early this morning some additional editorial style changes, and all of those have been incorporated into this document.
Latest document.
That's right.
Okay.
We've dated the document that these are the revisions that were done and through yesterday. They do include the email that was sent this morning with the editorial review that Arrigo did when we sent the typed version to him yesterday.
This is the same document that we got, except this is with the editorial changes in red.
And yesterday,
And
right,
yesterday, right.
right. And his
Right.
changes to any changes he might have made to the way we wrote it up yesterday in pencil.
Right, okay.
And I will explain on page 2, in subpart J, there had actually been a county ordinance that we didn't have a copy of that made a change. And so when that ordinance made a change, it renumbered the bylaws. Not having that ordinance in our possession or in my possession, I didn't pick that up. So really, this references to H above and not G. Because A was added when council had passed a later ordinance. So that's just a relettering in accordance with an ordinance that we didn't have. Page 3, nothing new other than the footer. Page 4 has the change in blue discussed by INR. Let me see. Well, really, this is what we discussed about the ex officio members. Arrigo's change. Yeah, I had following recommendation and nomination.
Right.
I think he changed it to read
Following a recommendation.
and nomination.
Right.
Right.
He changed it to be what?
Singular.
Singular. But I had following recommendation and nomination, and he had following a recommendation and nomination. We go down further. I think I had from a list submitted by the League of Cities, and I think that has been deleted. That has been deleted at the bottom.
Where's it deleted?
Bottom page 4.
Bottom of page.
Bottom page 4.
Stricken through.
And really, it was just, I think we said it yesterday when we were talking, but I think it's duplicative of the requirement's already in the provision, so that's fine. Page 5,
Looks like my old English teacher had a hold of this. My old English teacher brings back my English teacher days. A lot of this is
Just,
English teacher stuff.
right.
the top of the page specifically has been inserted between shall and might.
Okay.
Instead of to attend the meetings of the board, that has been to attend all meetings of the board. And to provide them with the agenda materials in the manner as provided, to provide them in the same manner as provided. So I don't know if that means I guess you could drop box them.
Yeah, we'll do the same thing we've been doing. We get the
Right.
information to them, send the
Right.
stuff to them. They won't know any different.
Okay. I discussed with you the courtesy notice to the League of Cities if the member concerned is the League of Cities nominee. That's in blue, so that was added. And a majority vote has been added. The word vote has been
Right.
added. All right, next page. We're good there.
Page 6. Look at page 6 on the board member could never serve again at the top. D.
Yes, D. D has been deleted, and I forgot to mention that, because a board member who has been removed by vote of the Board of Directors of the Solid Waste Authority shall not thereafter be reappointed. That has been in the bylaws for a long time, and it's always been approved by resolution of the council. However, it's not in the enabling legislation, so it has been removed. It is being removed
Okay.
because it's not in the document creating the authority. And the council's provision is the SWA board cannot prohibit someone from serving again when council has not itself placed that prohibition, which it legally makes sense because they're controlling who council can vote for, theoretically.
Okay.
So we really should not take issue. Okay,
Sentence above, you changed it too, didn't you?
oh, okay.
at least.
for a period of at
Two
least,
calendar years versus one now.
Right.
A board member be reappointed. Can only go back on after you've been out 2 years
2 years
versus one.
rather than 1 year.
oh, yes, okay, and I think that is one either I overlooked in my notes or we overlooked and we discussed it. That makes it consistent with the county policy on eligibility of board members to serve. And this had been an issue, I believe, in the past, years ago, but anyway,
6,
if you look at the top of page 6,
right there. Said change it from 1 year to 2 years.
because that is the
When you go
county
off the board,
policy.
you got to be off 2 years before you can come back.
And the
Was
county
one,
does
yeah.
have a policy
was one.
applicable to board appointees, and this is the requirement for the other boards of the county.
Okay, this is a change that was just put in this morning.
It was put in
And this
yesterday.
morning, but it was discussed yesterday.
Wasn't in the paper that was handed out yesterday.
That was an omission, Mr. Gray, but it was discussed yesterday. We had no discussions with Arrigo today.
I'm not disagreeing, I just want to understand
Right.
where the line is.
Right.
I have not seen this before.
No,
Right
sir,
now.
you have not.
Okay.
That was an,
Even if it was discussed yesterday.
right.
Got it. Thank you.
It was in yesterday's.
Yeah, it was.
Is
It
it
was
in
in
there?
yesterday's,
Yeah, it was. The change was in yesterday's change.
Yeah,
If
'cause I
you
thought I
look.
read
Okay,
it
then
last
I,
night.
But
sorry,
it was there.
It's there.
I
yeah.
failed to see it on my flip through this morning.
It's your old, you got your old one there. It's in, from
It's
yesterday.
in yesterday's on page
Yes,
6.
it is, I stand corrected.
Right.
Thank you.
Okay, and I stand corrected also. It's in there. All right, so, the county does have an ordinance relating to, it's under the administration section of the county code, and it does set forth requirements for boards, commissions, and committees, and this is the county requirement. So they've asked that this, and if they didn't, you could have these other boards and committees coming to them saying, you know, you need to change it for us, if, so they're trying to be consistent.
So in other words, if you're on the zoning board of appeals like I was for 2 terms, if I'm off for 2 years, they could reappoint me to that board, is that what you're
That's
saying?
right.
Okay. I didn't know
You going
that.
back on the board?
Not necessarily. Just, I did not know that.
Just in case, huh?
Information only.
We need that information,
That's
though.
right.
Information only.
Leaving your options open.
That's right, take that under consideration.
Section 3, at the end of the second paragraph, we took that sentence out. You know, this talks about special, not emergency meetings. So really, with the special meeting, there should be a statement of the purpose. So we just
Can I
deleted
catch
that.
Will you please, I got.
All right, page 6, Mr. Gray,
Help him, Mike.
Yeah, right here,
right there, we took that out.
right here.
This was what I got last night.
Yes, sir.
Thank you.
So the newest document, the latest changes are actually in purple. All the blue and red, it's the purple is the latest changes. All the red
That's
and
true.
blue had already been
Really had
done.
been in here, because we see a purple, now this was on page 7. That change was made yesterday. If you look at section 8, that should not have been, that was just, when it was being prepared, it was overlooked. And that is where I discussed the code section about county council inquiries, and directing everything through the county, the administrator. This brings it into conformity with the state code governing the Home Rule Act as it applies to the council administrative form of government. Y'all will follow the same.
Can you tell me a page where it's in purple?
7.
7,
7.
section 8, 3rd line down.
Just want to make sure I can distinguish
Yeah.
between purple and blue.
It's a
Yeah.
little difficult.
Oh, okay,
They marked through chairman as
It
the
was
first word.
red and they put blue on it.
Yeah.
okay.
Okay? Well, we did spell out on page 10, and this is from yesterday, in blue, the South Carolina Nonprofit Corporation Act. They wanted that spelled out in the parentheses, so we did that several places. Page 10 is an example.
Right.
Code site had to be corrected on page 11. That was a scrivener's error. Page 12, you see in section 4, the conflicting provision. That's the one we had discussed prior to INR. And the dissolution, we discussed also, but we took out the colon and 1 and the number 2 in parentheses and added approval by, we added ordinance there to clarify that, to make it read a little easier, but the meaning has not been changed. Danny, have I missed anything that you see?
No, but the people that weren't there, we went in, we had the red line, what you had looked at, and the county had a list of stuff that they thought needed to be changed. They went over that. Then we left, went out, we made those changes. They adjourned the meeting, and that's where we are now, attempting to get these changes to where you understand what they were based on guidance from the INR committee. But the good thing out of that was that they said, go change them, stay on the schedule that you own, keep your public meeting yesterday, keep your board meeting in the morning, vote them, get them to us by 12 o'clock, they'll be on the next council board
And they actually
meeting.
voted
Yep.
to vote it out. So
So,
What was the last thing you said?
they voted to vote it to
To
go
the
into
full
the
board.
council,
full council.
full council package, which was good. I mean, that showed confidence.
Sure. And the only changes after that meeting that were, changes were made after the meeting based on the INR meeting were these that Arrigo sent this morning, which are basically
Grammatical.
grammatical.
Grammatically.
Grammatical, right. And the ones that you saw yesterday, they're just
Right.
yes.
Yes.
They're just a few tiny grammatical things to the yesterday product.
Any questions or concerns?
I have a question. I noticed that during the INR meeting, the subject of the rules came up, and it was discussed. And it's not on the agenda for today. Does that mean that we will never and forever, ever again discuss the rules? We're not, also not on the agenda today. Some of us have obligations today. We're getting to the end of it. There's not going to be any discussion on the rules. Is that my understanding?
My understanding is we were going to.
Rules up.
But for us, approve the rules, that wouldn't go back to INR or county council. The rules would be our rules referenced in the bylaws. It wouldn't require the public hearing at all, is my
Well,
understanding.
part of the discussion, I don't say that it prevailed. I'm just saying part of the discussion was that the rules in some ways are nothing more than an extension of the bylaws and should be considered as such. They're not in the package today. And so am I saying that, or am I to understand that a decision has been made and the rules will not be considered part of our bylaws and therefore not going to be discussed today?
Mr. Chairman, if I may, in discussing, the rules are more like your Robert's Rules of Order slimmed down. They are your internal operating procedures for conducting a board meeting. And
They are that in substance, but they are also substantively designed to suppress discussion and exact discipline on members, censure, removal from the room, and other drastic means. In fact, Mr. Arrigo said that he would recommend that he use the phrase savings clause be added to the rules, which said that if any of what's in this thing called rules be in conflict with county council ordinances or procedures, they're null and void and cannot be enforced.
Go
ahead.
All right. I would like to point out, Mr. Chairman, that although the agenda's been approved and it's not on the agenda, we have incorporated a savings clause similar to the one in the ordinance as it relates to the rules, and that will be before the board for its consideration at such time as the board takes it up.
The clause is in the bylaws.
Well, it relates
So-
to the bylaws, but it's not in the rules, and we're not discussing the rules, and that's what I'm asking. Are we going to discuss the rules
Can we
or no?
discuss the rules? Can we,
The rules are not on the agenda when you asked for amendment, but just so there's no misunderstanding, I'd like to point out, we have drafted a savings clause, just as Mr. Karate suggested, and have put it in the version to be considered by the board the next time you take it under consideration.
A savings clause to go in the rules?
Yes,
Yes.
sir?
But what, okay, great, but there's, of course, you don't set the agenda, and you say,
Right.
until such time as, and,
no next meeting?
I'm sorry, I didn't understand what you said.
He was saying that the rules are scheduled for our next meeting for us to deal with in there.
Okay, well, I know you need to go, and I'm fine with carrying that over until my concerns relative to that. And that would affect how I voted today, but if you can give me your assurance that we'll discuss the rules.
They will be on the next agenda.
Thank you.
Any other questions or concerns?
Same concern I had when I voted no. One of the council people brought that up in the meeting too, about removing the debts and expenses being paid and saving the money for closure and post-closure at I&R yesterday, and said he had had people discuss that with him, and I don't know if he looked at the meeting or not. But that still is my problem, and that is why I will be voting no until that would be put back in. I think that everyone has responsibilities, and I'm sure the future council in 30 years, whomever they may be, will discuss, and the Horry County Solid Waste Authority directors will discuss, board members will discuss that as well. But as a board member today, I think that has been in there long before I got on the board. I think it is a good thing to have in there. My intent would be, whether it be my private company or whether it would be a board that I serve on, that it be in the bylaws that we pay our just and honest debts and our expenses, and that we keep separate. County council and the state and different things have their own rules and regulations on how they put up monies to pay insurance. There's been a lot of discussion of that with the county in the past. The Solid Waste Authority, which is very unusual to me as a public entity, and I have been an advocate for 25 years for the public and the community to be informed and to know what's going on and to interact with boards. So to me, I cannot, in all good conscience, let anyone think that my intent would be anything different than to pay and to put in our bylaws for us to pay our debts, our expenses, and monies that were taken out for a certain thing to be put up for closure and post-closure. My intent would be put in there. I certainly hope it's discussed at council level. I would hate to think that any of our council people would not want that to be done by the county, by any of their boards or commissions, because in the future, what it may be, and I hate to bring up Social Security, but when you take monies out and you don't use them for what they're designated for, then you have problems. You can get to a problem where you couldn't even tax enough to put that back where it needs to be, and if there were a problem, it may be many, many more $1 million than we have at the moment, or where the county could, in all good conscience, raise the taxes on their people to pay. I think that money was taken out with an intent, and as a board member, I would like for that intent to be shown, and if that isn't in there, I cannot support the bylaws. Thank you.
And I have just a brief comment, because that was an item of discussion. There are some safeguards in the dissolution provision in terms of net earnings shall not go to the benefit of board of directors, officers, trustees, employees, agents, or other private shareholders or persons. That's straight from the code. There are restrictions on the use of the money, and we had a further discussion yesterday afternoon about perhaps the need to educate the council as to EPA and DHEC requirements on closure, on financial assurances, on the possibility of permit revocation for the facility if the money is not safeguarded. And it might be appropriate for us to do just a little briefing memorandum that talks about financial assurance requirements that really acts as a public safeguard, or perhaps even, I don't know if you would go so far as to say a public constructive trust on those funds. It'd be good for the board members to know, and maybe be good to provide the information to county council too, as to the purpose and use of those funds in the future. Certainly we have, you know, between staff here and someone like Art Braswell, who worked for DHEC for years, we could certainly put, I think, something together, and it's been suggested that we do maybe do a little bit of education about this, so that the council and everybody's aware that this just isn't a general fund out there available to dip into.
Yeah, I agree with you. And not that I want to be argumentative or insulting to anyone, but over the last 25 years, having watched DHEC, and I'm not going to be insulting to them, I'm just going to say politically, they have not been able to protect the public's interest. If you read the newspapers for the last 20 years and see what's happened and whatever, they have not been able to. So public bodies that are supposed to be our safeguard and protect that is something that I haven't seen to be a possibility. That's why I feel like that has been in there for years. It may mean nothing other than an intention for someone in the future in 30 years to read that and maybe see what that intent was. But I still think it should be left in there. I don't think we should give our responsibility to anyone, whether it be DHEC or the EPA or anyone else. They all have their own responsibility. Council has theirs, and hopefully they will do that. But I think we as a board have a responsibility to give our intent and what we've done, and I don't see any reason why that should just be taken out.
Mr. Knight first, and then Mr. Gray.
Mr. Creech, I understand totally what you're saying and in your position, and we have looked to try to come up with some way to get to where you want to be. But I think we will take a different approach in our budget this year. We will have statements in there about closure and post-closure and justification and the rules and regulations. I think we can make it stronger in the budget. They have to approve it. They have to do things to change that budget if they want to get to the funding. And we heard yesterday that it's, they can change it, they can change the enabling legislation, and it's changed. No matter what we have in these documents, but I think we need to be firm in them. And I don't think, when it gets to full council, I think that issue will be an issue, that will be discussed.
Mr. Gray?
I concur with your concerns, and, but I also am recognizant, if that's the right word, that there is very strong feeling in county government staff and a majority, if not unanimous, that county government is in charge of everything related to Solid Waste Authority, and that, as Mr. Knight just pointed out, they can change any and everything we do with resolution and just do away with 6090, and then do with us and anything that we've done. Also, even now, we bond the full faith. In other words, we have to send in a certification to DHEC every year, and we bond the full faith and credit of the county as it relates to the landfill and activities of as it relates to things like closure and post-closure. Future councils may decide, as you said, may decide to use escrow funds for other emergency type, or what they would deem as emergency type purposes, such as a hurricane or whatever. But I understand where you're coming from, but we carry it to its logical conclusion. This flies right in the face of who is responsible and who has ultimate authority over solid waste management and funds related thereto. And I can tell you that it's my feeling that county council, and the way the law says, that county council is obligated to see to that responsibility, including stewardship of the funds. So I agree with what you're saying. I think they should be set aside. But by the same token, I recognize that that members, in fact, Mr. Etheridge and Mr. Arrigo made strong statements yesterday. Said, well, no matter what they say here, we're in charge. And nobody disagreed with that.
I agree with you. They are in charge, and they will be responsible. Responsibility comes with being in charge, and our council is. And whatever they may do, they will also have to bear the brunt of that responsibility. And this council or anyone else can change what we do here. What I'm saying is they cannot change my opinion or my intent. That they can't change. Thank you.
I think one of the, I just asked attorney here a question in terms of that. And I think the bottom line is that regardless to how we write it, county council can do whatever they choose to do. Yeah, and I think that's where we are at this point.
Yeah, I call for the question. I'll even make the motion.
Yeah.
I want to put a condition on my vote, but I move that we adopt the minutes as have been.
You mean the bylaws?
I'm sorry, the bylaws, thank you, as have been presented today.
Is there a second? And properly moved in second that we adopt the bylaws as been presented today. It's open for discussion.
I will vote yes, but conditionally yes, and that's based on the fact that I personally feel that our rules should be a part of the bylaws. I've been given assurance by the executive director and the chairman that we will discuss that at the next meeting. So I just like to take my feminine side that my opinion is subject to change. I vote yes conditionally. I even made the motion conditionally.
So is that a yes vote from you, Mr. Gray? I'm sorry, Mr. Chairman, is that a yes vote from?
That's what I'm getting at. He made the motion that we accept the bylaws, but, you know.
Ain't voted yet.
my assumption is you're voting yes, we present the bylaws, but then you're adding a condition. The issue is before I can carry the motion, is
I
that,
voted as clearly as I know how. A
We-
conditional yes, and I explained the condition. You can call it anything you want to.
I understand that, Mr. Gray, but I'm trying to get some clarity here for the sake of carrying the motion. And you may have to help me, Amaru. The issue of it is that these go to council before our next meeting. So we're going forward with
If
that.
you're gonna box me into a corner, box me into no, for the reasons I just mentioned. I'm fine with, all the work that has been done to date on the bylaws. I think, they're good. But I got another issue that's not being discussed today. I put that into my vote. If you're gonna force me to vote yes or no, then I vote no.
Then you have to withdraw your motion.
I beg your pardon?
You have to withdraw your motion.
I can't speak to that.
But
You got the gavel.
may I suggest?
Yes.
It reminds me that, if I get it right, that old saying, a card laid is a card played. So when you vote, I think it's kind of like that, but I certainly think, Mr. Gray, you could state your disagreement with having voted that way if the bylaws are not, if the rules are not discussed, you could put that on the record. I am not sure what the legality of withdrawing a vote that has been made would be, so I can't tell you that you can,
Well, and
you could
finally,
legally
now-
place that condition on there, but you
Well-
could certainly state your disagreement later in the record.
Okay. In the final analysis, we all know what's going to happen. Mr. Schwarzkopf put the train on the track yesterday, moved it along. It'll be slam bam, thank you, ma'am, Tuesday night week. So it really doesn't matter what I say.
Well, it does matter because you're a member of the board and you have a vote and, it matters. So-
Well, I voted the best way I knew how.
Okay, I'm going on your motion. It's our intent to deal with the bylaws, with the rules at our next meeting. So we've got a motion on the floor that we present the bylaws as distributed today to county council. We've got a second. Any other discussion? All those-
Will it affect the way this goes, because he did, tack on a, so I reckon what I'm asking is, Mr. Gray, he made the motion and he said he would vote yes, but he tied it to, the rules. I mean, if he wants to withdraw, I'll make the motion, and
The issue is that the rules will not be,
I'll withdraw and let Mr. Thompson do what he wants to do. I'm sorry, Mr. Campbell. I'm sorry. Looking at the signs wrong. I withdraw.
okay. Motion withdrawn.
I make a motion that we send the amended bylaws up to, county council.
Is there a second?
Second.
Been properly moved in second that we send the amended bylaws up to county council. Is there any further discussion?
Yes. I will vote no.
Wait a minute, it's not voting time yet, it's just discussion time.
I didn't say it. You didn't allow me to finish my sentence.
Okay,
I have no problem with the bylaws. I support the bylaws. I will vote no for reasons similar to Pam, that I think the rules should be part of the bylaws. But that's the end of my discussion. Thank you.
any further discussion? Okay, we've got a motion that we send the amended bylaws to county council as was presented this morning. All those in favor make it known by saying aye.
Aye.
Opposes?
No.
2-2. My vote is that we send it up, yes. So it's a 3-2. We send the bylaws to county council as presented. Okay, for our next meeting, here is a copy of the rules as we have worked on them. If you would, please make certain that the absent board members get a copy of the rules before our next meeting. We will discuss those on the next meeting. They'll be on the agenda.
Are these any different than the ones that we had the last time we talked
Yeah,
about?
these are the red line ones that we went through and made the changes and adjustments in it so that we'll know exactly what we're voting on. As a matter of fact, they're blue line.
We added the savings, any provision that conflicts with,
Okay.
any ordinance, bylaw, et cetera, is repealed. The language.
Nothing else of substance besides that savings clause, right? I
Right.
know there was some English,
Just grammatical.
Grammatical and,
English teacher stuff in here, but, okay, fine, thank you.
Okay. All right, there's nothing else on the agenda for today. We do need to set a meeting for public hearing, October 23rd. We need to look at your calendars, see if we can do that at 2 PM on October 23rd.
What will that be for?
Public hearing, to receive public input from our amended and restated rules, from these rules here before our final meeting.
Okay. What date did you want to do it?
Looking at October 23rd at 2 PM.
October, I'm sorry, to get over to the right page.
Is that the date that you were checking on?
Yeah, we're double checking on that. But,
Could we, if we're gonna have the public hearing, could we try to have the Finance Administration Committee meeting?
Same time, well, afterwards,
that?
afterwards, yes.
I'm fine with October 23rd, 2 o'clock.
Yes, sir.
I got to go do a EKG. I hope y'all ain't got me so damn nervous that I'll flunk. Then I got to go see about my eye. I swear getting old as hell.
Not for sissies.
Okay. Nothing else, then we entertain a motion to adjourn.
So moved.
Second.
Properly move the second, we adjourn. Meeting's over.
Thank you.
Thank you, everybody. If you'll check, if that afternoon you
Yeah.
can do that, then